Hello and welcome everyone. We're thrilled to have you with us today, all the 200 participants dialing from across the globe. Looks like our topic today has sparked some neural networks. So today's webinar is all about intellectual property protection for AI creations and inventions, a field that's evolving almost as fast as AI can write a Shakespearean sonnet. We'll look at how jurisdictions around the world are addressing the IP implications of our creations and inventions. So before we let the algorithms run wild, a few practical details. So we've included here a screenshot of the attendee interface. So no need to reverse engineer anything. Today's session is being recorded and you will have access to the recording as from tomorrow. You'll find the presentation slides and a few extra goodies in the documentation tab. That's the arrow B that you can see here on the screen. Um, and you can send your questions at any time via the questions tab. We'll gather them throughout the presentation and answer as many as we can during the live Q&A session. And if time runs out before we get to yours, don't worry, we'll follow up with you by email faster than ChatGPT can answer you. At the end of the webinar, a quick feedback survey will pop up. Your insights will help us improve, and for every response we'll receive, we'll plant a tree. So your opinion will also have some roots. And now let's introduce our human intelligence for today. So first we have my colleague Ola, who's with me in Brussels today. She's a senior media analyst at Cullen International, and she keeps a close eye on EU regulation affecting the digital economy and audiovisual sectors. She holds an advanced master's degree in IP and ICT law from the Catholic University of Leuven here in Belgium. And we also have Jose, who is joining us bright and early from Albuquerque in New Mexico. Good morning, Jose. So Jose is a principal analyst in our Americas team, covering regulation in the media, telecoms, digital economy sectors. He is a practicing lawyer in the US with experience in copyright, consumer credit, and business transactions. So basically, if AI paints it, sings it, or dreams it, Ola and Jose will be able to tell you who owns it, depending on the jurisdiction, of course. So as you might have guessed by now, my introduction was written by a well-known AI app. So hola, Jose, do I own my introduction? So I'll pass the floor to you so you can answer my question, and I'll see you later for the Q&A session.
Okay, thank you very much for joining us. Thank you, Sarah, for that introduction. And I'll try to answer your question, and we will go about it in a number of ways by looking at different jurisdictions around the world. But for all our guests today, many of you may not know what Cullen is. And let me tell you, Cullen International is a firm based in Belgium at the heart of Europe. But what do we do? Why do businesses and governments come to us? Well, we provide research, we provide training, and many other services in the area of regulations and law around the world. We're not a law firm, but when governments and businesses need answers about what laws or regulations apply in different sectors, like you can see on the screen, they come to us. We're neutral. We have a very strict neutrality policy, so our point of view is very objective. We just want to provide answers so that people can do business or run government the best way possible. That's why we call it regulation made simple when we describe what we do. All right. Well, with that, let me move on and tell you that this webinar is based on a flash news report that I wrote for the Global Trend Service, which is one of the services that Cullen International offers. It was titled exactly like this webinar, Did a Human Make That? And it was an analysis of the legal status of AI-assisted intellectual property, such as inventions and works of creativity around the world with a focus on the latest U.S. policies. Now we may move on to the next slide. Um, I can tell you that the U.S. Has a very long tradition of copyrights and patents law. It's part of the Constitution. But the way that I'm going to go about it is describing it, starting with some basics, and then I'm going to move on to um, different jurisdictions around the world. And the next slide, you can see our outline, so you get an idea of how I'm going to move through this. I don't have much time, so I'm going to go a little fast because I need to leave some time for my colleague Ola, who will also may jump in during the conversation because she has insights from Europe that she may want to share. And what are we going to start with? First, why do we protect intellectual property? Then I want to go into the U.S. policy and law on how copyrights and patents are protected when AI is involved. Then we will cover the approaches around the world. I didn't cover every nation in the world, but I did cover several as part of my research. And then I did some new research for this presentation, which is not part of the report I wrote on this topic. And this is the heart of the policy rationales in the U.S. And I'd like you to think if the policy rationales that I'm going to present to you are good for the U.S. only, or would they be good in your own countries? I think you may be surprised that some of the law and the regulations that apply here make a lot of sense because if we started giving IP protection to every creation of AI, something bad may happen in a number of areas, including the markets for these important goods, creative works, and inventions. And that's where I'm going to describe the potential negative impacts, which is at the bottom of our outline here. Now, I'm working with 3 monitors, so if I start looking to the sides, please don't think that I'm getting distracted and forgetting that I'm talking to you. Okay, so why do we protect intellectual property? Why do governments around the world offer authors' rights, copyrights, and patents to people and to businesses, corporations? Well, right now, in around the world, copyright, which is a collection of exclusive rights that authors or owners of creative works of authors have. Um, Copyright is the basis for a very large part of the global economy. We're talking about books, we're talking about movies, music, and to a lesser extent, the other arts such as paintings, photographs, which in some sense also become part of a market for media. But also there's photographers and artists who sell their work at galleries, sometimes for a lot of money. So that is a very large part of the global economy. And patents protect inventions, and many nations recognize patents from around the world. And it's important to recognize them and protect them because patents stimulate the development of technology, the development of science and innovation. And that's how we get not just great machines like tablets and cell phones, but we also get a lot of medicines and medical treatments through protected by patents, and that is very important for world health, as you can imagine. So, what is the questions that we? One of the questions that we want to address today is if AI is now capable of creating artwork and inventing things, does do AI apps own these things that they create? What is the law around the world and or regulations that apply in these cases? Do AI systems have the legal capacity under the laws and of different jurisdictions to enjoy the same rights as human creators and inventors. So if we move on to the next slide, we're gonna address that question a little more specifically. Um, what is the U.S. policy in this regard? And we'll see on the next slide that there are some important questions that have popped up already in terms of the legal capacity of non-humans to own copyrights and inventions. When I talk about non-humans, as you will see in the next slide, I'm not just talking about computers. In the U.S., a few years ago, there was a legal dispute with the government over granting copyright to a monkey that took a selfie of itself. And this went all the way to court, and in 2018, the monkey selfie case, which the monkey it was called Naruto, and the case is known as Naruto versus Slater. This case was decided against the monkey because the U.S. has a very strong tradition of not granting copyrights to non-humans. Okay, so before they started thinking about like, do computers have the right to own copyrights? This was already being addressed by the question of the monkey Naruto. But even before that, there was a question of whether a copyright could be granted to a bunch of plants in the United States, because a garden had developed in a very nice way, and somebody wanted to grant the copyright in the shape of the garden to the plants. So they tried to register it, and of course they were turned down. But as you will see in the next slide, this has a foundation in U.S. Law, and it is also enforced by the U.S. Copyright Office, which is where you go to register a work when you want to get a copyright registration. Copyrights in the U.S. are automatic upon creating something and fixing it on paper or a photograph or a computer file, but you need to register it to be able to protect it in court. So people are incentivized to register it, and these copyright applications for registration sometimes are rejected by the Copyright Office because they don't meet the requirements for copyright. And recently, the rejections have been over AI. Another recent rejection, even more recent than the monkey case, is a painting created by an AI application known as the Creativity Engine, which was created by Professor Stephen Thaler, of whom we're going to talk a little more in a few minutes. This painting, you might have heard about it. It was called Recent Entrance to Paradise. That's what it was called. And it was rejected because the fact remains that in the U.S., under current law and hopefully forever, only human beings can get copyright. And the human role, therefore, in an AI-assisted creation is crucial. If there is not enough human involvement, an AI painting or an AI song or an AI story is not going to get copyright protection. And this is just a consistent principle throughout legal U.S. history. As I've said, animals can get it, plants can get it. It has to be a human being. And it's not only in the law, but it's also in court cases that this has been decided. Why is this? Well, because the fundamental purpose of copyright is to incentivize creativity. Okay, incentivize the enrichment of the arts, of literature, of photographs, of stories, movies, etc. Okay, so that's why U.S. law makes a distinction per the U.S. Copyright Office and its procedures for accepting registrations, between AI as a tool, like a camera, a photographic camera, and AI as creator. So it's been established in the past in U.S. law that when you're taking a photo, the machine is not the one that is deciding what angle you take, what the picture is going to look like, how dark or how bright it's going to be. Is the photographer behind it a human being? The camera is only a tool, and the legal view has evolved similarly for AI. That AI is only a tool, and it doesn't matter how much input an app puts into a work, it's not going to be granted copyright protection. Okay. So these applications for registration are going to be evaluated on a case-by-case basis to see how much human input there has been, because just typing prompts on ChatGPT is not enough to find a human input that is worthy of original creative expression status, which is one of the fundamental requirements for copyright protection. All right, if we may move to the next slide, please. I was mentioning Professor Stephen Thaler. You may have heard about him. He's, if not very popular, he is very well known in IP circles and maybe a little infamous because he created I think it was called the Creativity Machine, an app that makes paintings. But also he created a program known as Davos. And Davos invented a container for food or drinks, which is to keep them either cold or hot. And it also invented an emergency beacon, a flashing light for people to use in urgent situations so they can be spotted. Okay. Now, why you're probably telling yourself, like, how is this an invention? These things already exist. Well, Davos went about it in a different way, finding different solutions to achieve the same results that you can find at the store when you buy a food container that maintains food temperature, or a flashing light in an emergency. So Davos did use some methods to achieve these designs for an invention that had not been considered by humans before. And that is important when it comes to inventions, the novelty of it, a solution that has not been found before. But there was no human input, and patent law in the U.S. is very clear that there has to be a human behind inventions as well. Now, before I move on, you're probably asking yourself, speaking about intellectual property, where did you get that picture of Professor Thaler, and do you have permission to use it? I don't need permission under U.S. law because it's just a tiny bit from a movie. But the movie is called AI Decoded, and you can learn more about it on aidecoded.com. It's a documentary about AI and its creative capabilities. But at any rate, Professor Thaler took his invention to the U.S. Patent and Trademark Office. Well, not his invention, Davos's inventions, both of them. And he got turned down by the U.S. Patent and Trademark Office, and then he took this to court. And the court ruled that he was just wasting his time and the U.S. Patent and Trademark Office's time, because he wasn't going to get patents for Davos's inventions. U.S. law does not allow it. Okay, what does U.S. law say about this? We'll discuss it on the next slide. U.S. law is very clear. It's written in the law, and it's also the result of court cases setting precedent that only natural persons, human beings, may be inventors. Okay, and the standard for recognizing an inventor, a human inventor, is that an invention has to be the product of the inventor's conception. What does conception mean? It means the shaping in the inventor's mind of the idea of the complete invention. Okay, so if this is carried out by AI, then it's not going to happen. There's no patent is going to be granted under U.S. law. Okay. However, this doesn't mean that AI assisted inventions cannot be patentable. And the same goes for copyright. Okay. The fact that you need a human being involved in creating copyrightable work does not mean that AI assisted creative works cannot be protected by copyright. It's just that the protection has to be granted to the actual human input, not to the AI input. Um, and it's the same for patent. If AI came up with a bunch of solutions for problems that resulted in an invention, well, if there's no human role, there will not be any patent granted. But if an inventor used AI to help the inventor come up with the invention, then there might be some patent protection. Because the important thing is that there is a human role in these creations that are copyright protectable, and in the inventions that are patentable. Because with at the end of the day, just as with copyright, patent is also designed to incentivize human creativity and ingenuity. We want to get human beings excited about possibly being rewarded financially with a patent or a copyright. So that's why that's what's behind U.S. policy in this regard. That we want to stimulate creativity and ingenuity, so that we get more inventors, more artists, more movies, more books, more inventions, more medicines, more fun devices like iPhones, etc. Okay. Now, if we may move on to the next slide, let me discuss what are the approaches around the world when it comes to granting copyright to AI-assisted inventions. Now, in terms of copyright, most of the world is that I happened to study, which was countries in the Asia Pacific region and UK and Canada. They seem to be divided over what their standards are, because as you can see, we go alphabetically in Australia, in Canada, and in the UK. We have different approaches. In Australia, human authorship is required to grant a copyright, but it is not clear under the current law in Australia who would own an AI-assisted copyright. Would it be the AI app or the human being? There's no answer yet. It hasn't been resolved. The similar situation in Canada. In the UK, it's a little more fuzzy because UK law actually grants authorship to persons behind computer-generated works. So we know who the author is under the law, but it is not clear under this same law who would own the copyright, the human being or the AI app. So there's still work to do in some jurisdictions. In Asia, Korea is a little more solidly ahead in achieving clarity, because it is the legal standard there that human authorship is required to grant a copyright. And there is guidance for their copyright registration agency on how to go about analyzing a creative work to see whether they would grant copyright to it or not. But in India, very similar to Canada and Australia, human authorship is required for copyrights, but it is also unclear who would own the copyright, human or AI. And in China, Chinese law doesn't say anything about the human role. Okay, and it is also not clear who would own the copyright, the human or the AI app. There's been some legal decisions in China that seem to be okay with recognizing copyrights in AI created works with no human role whatsoever. So there's still some work to do in these jurisdictions in terms of copyright. In the next slide, I want to discuss patents. And in this area, around the world, we have a little more developed law and regulation, with exception of India, which I'll get to in a minute. But in Australia, in Canada, in China, in Korea, and in the UK, if you have an invention and there's no human being involved, there's not going to be any patents granted. Okay, human contribution is required, and AI inventorship is forbidden by law in all these countries. That's Australia, Canada, China, Korea, and the UK. India is the exception. It is just unclear, because the Indian law doesn't say whether human inventorship is required for an invention. It's just not explicit in the law. It's presumed that you need a human being, but the law doesn't say. Okay, and AI human collaborations may be recognized in India, but the law still has to be developed in India. We don't know who would own these inventions and patents under patent law in India. It's just not clear yet. All right, moving on to the next slide. What I want to discuss next is the reasons that were stated by these U.S. government agencies on why they don't want to grant these rights to AI applications, or grant any legal protection to IP that is generated by AI only. Okay, the U.S. Copyright Office made it very clear in one of its recent reports on this matter that if they start granting copyright protection to AI only works, the protection for human creators are just going to become weaker. It's just not going to be as important to create as a human being, because at the end of the day, it's a lot cheaper and quicker to create with AI, as any of you who have tried it probably already know. And this can have market effects, as we will see in a few minutes, that it can be very detrimental to human creators. And the U.S. Patent and Trademark Office has a similar rationale. The purpose of patents under U.S. law, again, is to balance incentives and to provide incentives for human inventors, for human ingenuity. And when it comes to AI, one has to take into consideration the market. Once again, as with copyright, there's also a market for patents. And a lot of money goes into financing inventions such as medicine, gadgets and devices, electronics, vaccines, and other solutions to human problems. And you need to balance the incentives for human ingenuity and investment with the incentives of coming up with quick, fast, and cheap inventions through AI. Those incentives are not going to be there anymore if AI only inventions, start flooding the patent market. And the USPTO, the Patent Trademark Office, also wanted to make very clear in their explanation of their policy that patents are meant to reward human creativity. Okay. Again, it's an incentive to be creative, to come up with solutions for problems. So if you start granting patents to AI apps who don't have to pay bills, are not interested in being famous, and so on, well, at least not yet, well, then that reward and incentive system falls apart. But being a little more specific, you'll see in the next slide, I did some additional research on the dangers, the negative administrative impacts. In this case, I'm going to go into the negative impacts in three areas: administrative, enforcement and market impacts. All of them negative. There's not a whole lot of positive to discuss, and at any rate, the the negative impacts are what I want to focus on, because this is very likely um, the reason why the U.S. Copyright Office and the U.S. Patent and Trademark Office are going to be opposed to granting IP protection to AI-only creations. Now, in terms of administrative impacts for copyright registrations, if we removed human authorship requirements, the U.S. copyright registrations would just explode. Okay, there are already many of them as it is right now, and if we start letting AI models get copyright protection, well, think about this. According to Nixon Peabody, a law firm in the U.S., AI models currently generate about 10 million images per day. Okay, that's a lot, but it's grown 50% in recent years. Between now and 2023, if I remember correctly. That's a very big increase. So next year was probably going to be 20 million images per day. Imagine the Copyright Office trying to provide copyright protection, registrations, and taking care of the paperwork for 20 million images per day. And that's just images. What about videos? What about music? So this could get very literally crazy very fast. The University of Virginia in the U.S. Also had some interesting facts that in the last 5 years, the U.S. Copyright Office processed 2.3 million registrations. Okay. This is not a large office. Okay. They don't have millions of people working there. So that's a lot of registrations to process. And if we flooded the market for creative works with AI works eligible for copyright registration, they would just be overwhelmed over there at the Copyright Office. We would not see copyright registrations being processed. And in China, according to Mondac, the content aggregator, there was 8.9 million copyright registrations in 2023, and that was a 40% increase from 2022. So it would just get very bad in terms of administrative impacts very quickly if the law recognized the copyright protection for AI only works. Okay, now if we could move on to the next slide. Negative administrative impacts for patent is something very similar. Okay, if there was no human requirement for inventions, the U.S. patent system would also see a surge in applications that would be impossible to handle. And as it is right now, there's already a lot of processing delays at the USPTO. Okay, in 2024, according to my research, USPTO research, I'm sorry, not mine, but I did look it up. There were 1.19 million patent applications waiting to be processed in 2024 at the USPTO. Okay, and the increase in unexamined patent applications waiting to be processed between 2021 and 2024, according to USPTO data, was over 23%. So inventions keep coming in, patent applications keep coming in. USPTO cannot keep up as it is right now. Okay, if we start recognizing AI inventions, AI only inventions, it would get even worse. Now, let me move on to the next slide, where I want to talk about negative market impacts. Now we're talking about money and value. Okay, the more you have of something, the cheaper it becomes. That's just simple economics. And there's data from the content management firm Agility that shows that right now the amount of uploads of content that go to the web, YouTube, Facebook, X, any other social media platform where people upload a video or photos, Right now, it's already saturated with 500 hours of video per minute on YouTube being uploaded. Okay, that's 500 hours of video per minute. 35 million Facebook status updates per minute. 518 million tweets on X daily. Okay, imagine how this would explode if we had the copyright protection um, for AI only works. Now, I'm going to start moving a little faster now because I'm running out of time, and I want to give time to my colleague. Um, but yeah, in patents it would be something similar, and we can see it in the next slide that the patent market is also very valuable in around the world, not just in the U.S. but in the U.S., we're talking about $60 billion in 2023 of patent licensing. You know, paying for permission to use a patent to manufacture an invention. If we flooded the market with low value patents, which they would be low value because they would be very cheap to make with AI, you know, quick and easy. Then this market would collapse. The licensing market would collapse. There would be no incentive to invest in inventions. And the big tech companies, which own a lot of patents already, they would become impossible to compete with because they would have a lock on valuable patents, and at the same time they would be making cheap, low value patents with AI. All right, the next slide, please, is about negative enforcement impacts, and I'm just going to move quickly through this. Protecting copyrights costs money. You have to go to court to sue for infringement. And if we start seeing a lot of AI copyrights, you know, a flood of AI copyrights, the U.S. courts and most courts around the world are not going to be able to handle all the losses that would result because there's likely to be accusations of infringement. Remember that AI apps base their outputs on stuff that's already been created, and we've already seen some of those lawsuits. The Disney Studios and Universal sued Midway for its capacity to create, you know, characters from Disney movies and Universal movies. That would, there would be a lot of lawsuits that would not be able to be resolved in a reasonable way. And on the next slide, you'll see that with patent, something similar would happen. In particular, patents are disputed all the time, and because there's a process for invalidating patents that have not been granted, presumably that have not been granted according to law, and the USPTO manages this process on under the U.S. Patent Trial and Appeal Board. And there's already 70% of invalidation petitions are approved. Okay. Imagine if there were more invalidation petitions because there's this flood of AI patents. There would be even more work to do for the PTAB, the Patent Trial and Appeal Board, and they probably wouldn't be able to handle it because they're a small organization. So at any rate, I am going to stop talking now so that Ola can continue. And in a little bit, we will discuss Q&A because there are ways to register for copyright works that have been assisted by AI, and there are ways to also register, apply for a patent for works that have been assisted by inventions that have been assisted by AI. It's not impossible, not under U.S. law anyway. All right, thank you very much for your time.
Hello, everyone from sunny Brussels. I will give a perspective on AI authorship and inventorship in Europe. So in Europe, the topic of AI authorship is absent from the EU policy debate. The center of the debate is instead human authorship and how the works of human authors are being used to train AI systems. So the center of the debate is the fair remuneration for authors and the holders of neighboring rights, such as producers, publishers, broadcasters, how to remunerate them for the use of their works for training AI, generative AI. So AI that generates new works. Under the Copyright Directive in the digital single market, there is a text and data mining exception provided for the use of copyright protected works in its Article 4. This exception applies under conditions that the content must be accessed lawfully and the right holders mustn't have opted out. So it applies to anyone if these conditions are fulfilled. Why is it important in the context of AI? Because text and data mining involves automated processing of large techniques to process large amount of data. And this is especially important at the stage of collecting and processing data for AI training. So the fear is that AI companies may use this exception of Article 4 to mine copyright protected material without properly remunerating the rights holders if they haven't expressly asserted their rights by opt-out. Following raising concerns, a provision has been added to the then draft AI Act. It has been adopted in 2024. And there has been a provision, a transparency requirement added to Article 53, which requires providers of general purpose AI, so AI which can fulfill a variety of different tasks from writing to creating images and videos, etc. So providers of general purpose AI have to implement policy ensuring compliance with EU copyright rules, including the opt-out of Article 4 of the Copyright Directive in the DSA. In the digital single market, And they have to also provide summaries of data, of the training data. However, there are no specific rules in the AI Act, neither in the Copyright Directive, on AI authorship or on the copyright protection for AI works. Next slide, please. There is also no ruling of the Court of Justice, this is the EU top court, on the question of AI authorship and copyright protection for AI-generated works. However, based on existing case law of the court, we might assume that human creativity is a requirement, human authorship is a basic requirement. In its previous case, in its case law, the court decided that so this case law is related to the concept of originality, which is required under EU law to have copyright protection for the work. So the court already decided that a work is considered original, thus deserves copyright protection, if it reflects the intellectual creation of its author. And in relation to a portrait photograph, the court said that the work can be, the photograph can be protected by copyright if it reflects the personality and creative choices of its author. Creative choices like lighting, pose, angle, composition. So based on such case law, we might assume that AI generated works can have copyright protection in Europe if there is a substantial human creative input. However, the questions remain because AI evolves so fast. The questions remain what to do with the works created entirely by AI without human input, which have the same or a similar level of creativity. Then even if AI will be granted authorship rights, who will be exercising those rights? Will it be the company owning AI? Also, what is not clear yet is what to do with the moral rights, because here authors have moral rights, which means that they the right to be named, and also the right to oppose to the derogatory treatment of the work, so to oppose to bringing some changes which the authors don't want to the work. What to do with that. Also, it has to be noted that in Europe, databases have a special sui generis protection, so they don't need to comply with the high requirement of originality, but there is a need for substantial authors' investment in gathering data and in putting it together and presenting in a database. So for databases, the standard of protection is a little bit lower. Next slide, please. At the national level, courts also started addressing this issue. There has been a decision by the Prague Municipal Court that decided that AI-generated content lacks copyright protection unless sufficiently creative human contribution involved. This was the case of person putting a prompt to AI system asking to create an image of two hands signing a contract, and later on this image has been used by a law firm. And so in this case, the applicant couldn't prove that the work has been a result of his prompt. And in Italy, there was a decision that the Italian Supreme Court decided that AI work can be protected as long as it reflects creative contribution from a human author. Here was the case of an image of a flower created by Italian architect with the help of AI. And this flower has been used by a broadcaster during a famous music festival without copyright authorization. So here basically the court said the fact that it's created by AI, that the work created by AI does not exclude human creative input in this work. Next slide, please. Speaking about patents. So in Europe, patents are granted under the European Patent Convention. They are granted. It works separately from EU law. Patents are granted by the European Patent Office following the application. The European Patent Office is of the opinion at the moment that the current state as it is, AI cannot independently identify technical problem and find a technical solution to solve this problem. AI can assist humans in creating their works, to verify the result, or even come up to a solution to a problem identified by a human, but it cannot do both steps alone. The European Patent Office already grants patents for AI innovations in fields such as medical devices, aerospace, automotive, media, but as an instrument that assists a human. Under the European Patent Convention, Article 60, the right to a European patent belongs to the inventor or the legal successor. It's a common understanding that inventor is a human being. This has been confirmed in the European Patent Office guidelines, following the Dabus case, which has already been mentioned by Jose. So similar applications that has been done all over the world. So Mr. Stefan Teller also made an application to the European Patent Office. And the European Patent Office decided that it was already decided by the Board of Appeal that inventor must be a human, and that AI system cannot hold or transfer rights vested in the under the European Patent Convention because of the lack of legal personality. Next slide, please. Sorry, I forgot to mention that also in relation to the patents, the UK Supreme Court confirmed that AI cannot be named as an inventor under the Patents Act. So in Europe, the decision now is that the decision now of the European Patent Office is that AI cannot be considered as inventor yet. To conclude, in Europe, human creativity, remuneration, and transparency are the focus of the EU policy debate. AI authorship is not yet broadly discussed, however, it can change. Based on existing case law of the Court of Justice of EU, human creative input is required for a work to be eligible for copyright protection. And finally, under the European patent law, AI cannot be recognized as an inventor, not only because it remains speculative, so not only because for the moment it's a science fiction that it can come up with both identifying the problem and identifying a solution, but also because AI simply cannot exercise the rights vested in a patent. Next slide, please. I would like here to draw your attention to our reports on the topic of AI and copyright, which you can read afterwards. Next slide, please. So I'm very grateful for your attention.
Thank you, Ola and Jose. I found it super interesting. Personally, I hope our guests today found some interesting insight, and I'm sure they did. So if we move on now to questions, we still have a bit of time, so that's great. So I took note of a few questions that we have from the audience. So maybe just a simple question for both of you to make it clear, because well, I think at some extent we all use some AI app. So is a prompt considered as human creative input? I don't know who wants to start with it.
Well, Ola, do you mind if I answer about the applicable
Sure.
US law? Okay.
Sure.
So
Go ahead.
for copyright in the US, it's not enough, but the US Patent Office will recognize coming up with the right prompt engineering, fine tuning the prompt as enough of a human contribution. So if how you construct the prompt, has a lot to do with the result. And in terms of a patent, it will be recognized as a human input, but for copyright, it will not in the US. Okay.
Yeah. And in Europe, Ola?
In Europe, there is the requirement of originality. So if the prompt reflects the personality of the author and his creative independent choices, then it would qualify for the copyright protection. So it must be, in fact, it should be decided on a case by case basis. And I think it wouldn't qualify for the copyright protection because it doesn't offer, only if it offers a technical solution to a technical problem, but I don't see immediately how would it apply to a prompt.
Thank you. A question for Jose. What is the policy of the US Copyright Office when someone tries to register a work that combines AI-generated material with a human creation?
Okay. This is it's very simple, but also it's a little nuanced. If you try to register something that was created by AI only, the U.S. Copyright Office will reject it. But there have been instances, for example, of there was a case of someone who wrote a story and turned it into a comic book with AI, but the human being wrote the story, and the comic book art was created by AI. And what the Copyright Office did is that it granted a copyright registration to the actual writing, but not to the art. Okay, but there has been one case, a painting called a single piece of American cheese, and I wanted to share a PDF about how it was registered with the audience, if I could. Maybe
Yeah,
we
we
can
will send it
put a
tomorrow.
link
We
out
will
there.
send an email. If I
Right.
may interrupt, just to say that tomorrow you will all receive an email with the link to the recording, the link to the slides, and the link to the report that Jose just mentioned. Voilà.
Okay, great. Yes. This is about a single piece of American cheese. This is a painting. Was all the elements of the painting were all created by AI. But there was human beings that changed every single one of the elements, changed the colors, adjusted the colors, the saturation of the colors, how polished they look. And all of it was created by AI, but every one of the elements was fine-tuned and changed by a human being. And this company that created this is called Invoke. They are an AI firm, and they received the first copyright registration for an image, a single image that was created entirely by AI. And the reason why they got the copyright registration is because the U.S. Copyright Office found that there was a lot of human input. All the elements were created by AI, but everything was changed by human beings to make it look better. Just like editing a photo in Photoshop, something similar, parallel. So there's ways of doing it, and let's see if Olga has something to say
Yeah, Ola,
about.
how would that work in Europe?
I'm sorry, I thought it's only in relation to yes. Could you please repeat
So
the question?
if someone tries to register a work that combines AI generated material with human creation, so how would that work in Europe?
I think it would. I think it would. It would deserve a copyright protection, but then the author would be considered a human under the based on the current case law. However, there has been no decision of the Court of Justice yet on that.
Again, one last question, maybe more for Ola. Given that the AI Act now requires transparency about training data, does this mean that authors and creators will be compensated when their copyrighted works are used to train AI systems?
So under the exception for text and data mining of the copyright directive, the authors could be the authors are supposed to be remunerated if they explicitly opted out from the use of such works of their works for the purpose of text and data mining. The law doesn't specify how exactly they should opt out, and now it's a big topic of the policy debate how the rights owners should opt out, and there is uh, normally we are expecting this to be clarified in the code of practice on general purpose AI under the AI Act. So these things are still not clear, and also what is not clear is how the rights owners can know that AI has been trained on their works if there is no clear summary of the information. So this is the big topic now in the EU policy debate.
Okay, well, I don't see any other question. I'm just checking. I don't see any other questions. So, in any case, for our participants today, if you have any more questions that come up during your day or during your weekend or whenever, just drop us an email. We will always be happy to answer. Okay, so thank you, Ola. Thank you, Jose. Thank you, everyone, for attending today. Just some important information before we leave. So, as I mentioned, if you have any other questions, you drop us an email. And once you leave today's webinar, remember about this very short feedback survey. We would appreciate the feedback to make sure we keep getting better. And also, we will plant trees. So, lots of feedbacks, lots of trees, and a fresher air, which would be nice these days. And yeah, on behalf of Cologne International and our presenters, thank you for joining us today. Have a great rest of the day. Jose, have a great day. For us, it's almost over here in Brussels. Yours is only starting. Okay, so bye bye, everyone, and see you in our next webinar.
Bye. Thank you, everyone.
Bye.
Bye bye.